Whistleblower protections for SEC whistleblowers. The SEC Whistleblower program has been effective in combating fraud and protecting investors. Whistleblower tips have enabled the SEC to recover more than $2.5 billion, and the SEC has paid whistleblowers more than $500 million in awards. Understandably, whistleblowers are reluctant to come forward because they fear retaliation. Fortunately, the SEC Whistleblower program permits a whistleblower to disclose fraud anonymously by retaining an attorney to represent them at the SEC. And federal whistleblower laws protect SEC whistleblowers against retaliation. In particular, the whistleblower protection provisions of the Sarbanes-Oxley Act and Dodd-Frank Act protect employees disclosing potential violations of federal securities laws. The whistleblower protection provision of the Sarbanes-Oxley Act prohibits employers from retaliating against whistleblowers for reporting to a supervisor, law enforcement, regulatory authorities, or Congress mail fraud, wire fraud, bank fraud, securities fraud, a violation of any rule or regulation of the SEC, or any provision of federal law relating to fraud against shareholders. The whistleblower protection provision of the Dodd-Frank Act protects a whistleblower for engaging in these three protected activities. In contrast to SOX, the Dodd-Frank Act anti-retaliation provision protects an internal disclosure only where the whistleblower has reported a potential violation of federal securities law to the SEC. Laws authorize a variety of remedies for retaliation, including lost pay and benefits and reinstatement or front pay. And SOX authorizes the recovery of uncapped damages for emotional distress and reputational harm. There are, however, critical differences between these two whistleblower protection laws, including the scope of protected whistleblowing, the statute of limitations, and the requirement to exhaust administrative remedies. State laws can provide additional protection and potentially enable the whistleblower to recover additional damages. It is critical to retain a law firm with substantial experience representing whistleblowers and a thorough understanding of whistleblower protection laws. If you have suffered retaliation for reporting potential violations of federal securities laws to your employer or the SEC, call us today for a confidential case evaluation.